Imagine this. Something you choose to do, totally in private, in your own home, could actually get you into legal hot water. Not because you're hurting anyone, just take. Because the government says you can't. It really makes you ask that big question, doesn't it? Especially in, an open democracy. How far should the state be able to reach into our private lives? Particularly when it comes to what we consume behind our own closed doors. Today, we're doing a deep dive into a really crucial legal case from South Africa that tackled exactly this issue. It's Minister of Justice and Constitutional Development versus Prince. So our mission today is to unpack this landmark ruling for the Constitutional Court of South Africa. The specific case is CCT 10817. It was decided back on September 18th, 2018. And just so you know where we're coming from, this deep dive is based squarely on the court's own unanimous judgment. We're also looking at earlier high court decisions, plus other, key legal and medical documents they considered. It's all about understanding that balance, that tension between individual freedom and the state's power. Okay, let's get into it.
It really is a fascinating journey seeing how a case like this moves through the legal system. It shows how individual rights get tested, sometimes redefined right at the top, and honestly, how the courts can sometimes nudge society in a new direction.
Absolutely. And the start of this case, it's actually quite complex. It wasn't just one simple challenge. It was, I think, 3 separate cases that got kind of rolled together by the Western Cape High Court. You had people like Mr. Gareth Prince, Jonathan David Rubin, Jeremy David Acton, others too, all basically challenging parts of the country's drug laws.
Right. And what's really striking is seeing that escalation. You see this fundamental tension playing out. Individual privacy versus state control. That's a classic theme in constitutional law, really, all over the world. And the High Court, under Justice Davis, they made a pretty bold move. They essentially declared key bits of those drug and medicine laws unconstitutional. They said the government's ban just went too far.
And it's super important to get the scope of that initial High Court ruling right. It was specifically limited. It was about the use, possession, purchase, or cultivation of cannabis by an adult in their own home, a private dwelling, and only for their personal use. The court basically said the law is infringed on privacy, and they found the state's reasons for it, they called it singularly unimpressive.
Yeah, and they also brought in some important historical context. They referenced an older case, SV and Nkosi, and pointed out that historically, a lot of the cannabis criminalization in South Africa had roots in racism, which adds another layer, a really powerful one, to their reasoning.
So the High Court makes this big declaration, this law is unconstitutional. But in South Africa, that's not the final word. It automatically goes up to the Constitutional Court for confirmation. It's like a final check, right, to make sure everything's constitutionally sound.
Exactly. It's a crucial safeguard.
So naturally, the state, the ministers of justice, police, health, and so on, they appealed. They wanted the High Court decision overturned. But interestingly, the original applicants, like Mr. Prince, they also appealed a cross appeal. They actually wanted the ruling broadened even further.
And like you often see in these big cases, other people got involved. You had individuals like Mrs. Clark, Mr. Stubbs, Mr. Thorpe. They were allowed to intervene because, they were facing their own criminal trials over cannabis. So they had a direct stake in the outcome.
Makes sense.
And then you had Doctors for Life International joining as an amicus curiae, a friend of the court. They actually sided with the state, arguing against loosening the laws. It's also worth mentioning, I think, that a few other groups tried to intervene but were turned away, mostly because they were late or tried to bring in completely new arguments.
Okay, so let's get right to the core of it. The real legal battleground. Privacy versus prohibition. Section 14 of South Africa's Constitution, that's the bedrock here, the right to privacy. The Constitutional Court itself has described this as the right to be left alone. It protects that sort of inner circle, your personal sphere. They talked about this in cases like Bernstein v. Bester. It really underlines the idea that your personal space is, sacred ground to some extent.
And connecting that to the bigger picture, privacy isn't just about keeping things secret. It's tied to fundamental human dignity, to autonomy. It's about being able to make choices in your personal space without the state constantly looking over your shoulder unless there's a really good reason.
Right.
We see similar ideas elsewhere, too, like the case decision in South Africa about obscene material at home, or even Stanley v. Georgia in the U.S., both point to this idea of the home as a kind of sanctuary from state interference. It's a widely held principle.
But of course, the state wasn't just going to roll over. They had their reasons for the cannabis ban. Their main line was protecting public health, the health, safety, and psychological well-being of people. And also, the bigger picture, war on drugs.
Right. They brought forward evidence, like an affidavit from a Dr. Gauss. She detailed the alleged harm, psychoactive effects, anxiety, bronchitis, heart risks, issues during pregnancy. Her argument was essentially that cannabis was uniquely dangerous, much more so than, say, alcohol or tobacco.
Okay, and this is where the court really had to dig in and weigh things up, because there were counterarguments and a whole global context to consider. Medically, even an earlier dissenting judgment in the Prince Physic case had suggested there's probably some level of safe cannabis use, even if we don't know exactly what it is.
Yeah, and then there was the World Health Organization. The court highlighted their findings. The WHO basically said the negative health and social impacts of cannabis seem less severe than those from alcohol or opioids, which is pretty significant, right? Their data even suggested alcohol causes more problems globally in terms of treatment need.
And even closer to home, South Africa's own Central Drug Authority back in 2016 put out a statement. They suggested that alcohol causes the most harm in South Africa, individual and social harm, compared to tobacco and cannabis.
And, crucially,
Yeah,
they actually recommended decriminalization for cannabis. Not full legalization, but decriminalization. That's a big statement coming from a body like that.
definitely. And beyond the medical debate, there was this other point.
Mm-hmm.
The lack of solid evidence linking cannabis used directly to crime or, being a gateway to harder drugs.
Mm-hmm. Right. International cases, like one from Alaska, Ravin v. State, had already cast doubt on that old idea that marijuana automatically leads to violence or crime. Experts just didn't buy it anymore. So that whole war on drugs justification started looking a bit shaky when faced with this evidence.
And then the clincher, maybe? The global picture. This seemed like a real turning point in the court's thinking. The judgment explicitly mentioned, I think, 33 other places around the world that had already moved away from total prohibition.
Yeah, places like Canada, Uruguay, Portugal, Switzerland, a whole bunch of U.S. states, California, Colorado, New York.
It showed that other countries were finding ways to handle cannabis that were less intrusive on privacy.
Which leads to that crucial question, right? If all these other democratic societies found less restrictive ways, does South Africa's total ban still seem proportionate? It strongly suggested that, yes, less restrictive means were possible and viable, and that directly undercut the state's argument that a complete ban was the only option.
So all this analysis, all this evidence, led to the Constitutional Court's final decision. And it had a huge impact. First off, they confirmed what the High Court found. Criminalizing the use, possession, or cultivation of cannabis by an adult in private for their own personal consumption that is unconstitutional.
Yeah.
It violates the right to privacy.
But, and this is key, they also tweaked it based on the cross appeal. Remember how the High Court said, in private dwelling?
Right. In your home.
The Constitutional Court got rid of that limitation. They expanded it to simply in private or in a private place for cultivation. So your right to privacy isn't just confined to your house walls. It travels with you as long as you're in a private setting.
Okay, but equally important is what the court didn't do. They were very clear on some things. They specifically did not agree with the High Court about making the purchase of cannabis legal.
No.
They explicitly said, we're not sanctioning dealing. They saw dealing as a serious issue needing prohibition.
Absolutely. And they also didn't strike down a part of the Medicines Act about selling or administering cannabis, basically saying the case wasn't properly made for that. And regarding arrests under the Criminal Procedure Act, they said there was no need to change that law. Why? Because if private use and possession isn't a crime anymore,
then the police can't reasonably suspect you of committing that crime, so they can't arrest you for it.
exactly. The grounds for arrest on that specific point just fall away.
So how do they make this effective immediately? They used a legal remedy called reading in. Can you explain that? It sounds a bit technical, but it's really important for understanding the immediate effect.
Sure. Reading in is basically where the court temporarily rewrites the problematic part of the law. Instead of just striking the whole thing down and leaving a gap, they insert words to fix the constitutional defect, effective immediately. It's like an interim legislative fix by the court.
Got it. So they read in specific exceptions.
Precisely. They added wording to the Drugs Act, so the part about using or possessing cannabis now has an exception. By an adult in private for his or her personal consumption in private. They did something similar for the definition of deal in, making it clear that cultivating cannabis in a private place for his or her personal consumption in private is not dealing.
Okay.
And they added a similar exception to the Medicines Act for possessing scheduled substances, specifically exempting adult private use of cannabis for personal consumption.
So the bottom line for people listening, what does this actually mean? It means it is not a crime anymore for an adult to privately use cannabis, possess it, or grow it, as long as it's for their own personal use.
Yeah.
That's a massive change. It puts a lot more trust in individual privacy. But as you said, it's not a total free-for-all.
Definitely not. That's crucial. Using or having cannabis in public, still illegal. Using it around kids, illegal. Using it around other adults who haven't consented, also illegal. And very importantly, selling it, distributing it, that remains a crime.
Right. But then there's that practical question, the sort of gray area. How does a police officer on the street decide if the amount someone has is for personal consumption or if they're dealing?
Yeah, that's a tricky part in practice. The court acknowledged this. The amount someone has is obviously going to be a factor, but the burden of proof is on the state. They have to prove beyond a reasonable doubt that the cannabis is not just for personal use.
Okay.
The court used analogies like how police assess situations like potentially negligent driving or possessing suspected stolen goods. Officers use discretion. They look at the context, the circumstances.
Right.
Ultimately, if there's a dispute, it's the courts that will decide based on all the evidence in that specific case.
And this reading in, it's not necessarily the final word from Parliament, is it?
No, that's another important point. The court suspended this reading in for 24 months. That gave Parliament 2 years to actually amend the laws properly themselves, to bring them in line with the Constitution.
So it's a deadline for the lawmakers.
Exactly. The court basically said, here's a temporary fix. Now, Parliament, you have 2 years to create a permanent, constitutionally compliant solution. If you don't, our reading in becomes the final law.
Wow. So wrapping this up, this Prince case is undeniably a major win for the right to privacy in South Africa. It completely changed the legal status of cannabis for personal use, shifting the balance significantly. But, as we've stressed, there are still clear limits and boundaries.
Absolutely.
It's just such a powerful example of how these fundamental rights, like privacy, aren't static. They get debated, tested, redefined as society evolves, as we learn more, and as we see what's happening globally. This whole deep dive really makes you think, doesn't it?
Yeah.
Not just about what the law prohibits, but why do the reasons hold up under scrutiny, especially in a society that values openness and democracy. It leaves us with that big question to mull over. How do we strike that balance between individual freedom and the collective good, particularly when the evidence and maybe even social norms are shifting? Something to think about.